This may sound strange, but I am simply doing this in compliance with the Court of Appeal's decision in the minor KI case. This decision by the appellate court requires me to treat the results as tabulated by the various returning officers as final, and not to attempt to verify them against the electronically transmitted Forms 34A. You will therefore have to bear with me, as court orders must at all times be obeyed. However, all hope is not lost, since I have availed all the Forms 34A on our public portal. Any candidate, election observer, or member of the public is free to download these forms and compare the results thereon against the ones I am just about to declare. If such an exercise should reveal serious discrepancies, then one can petition the Supreme Court to scrutinize them and even annul them, since the Supreme Court has original and exclusive jurisdiction over such disputes. He failed to do the above, and apart from the duty to verify, the first respondent also has the responsibility to ensure that the system of voting, counting, tallying results is verifiable. This is in conformity with the Article 86 of the Constitution, which requires that, quote, at every election, the Independent Electoral and Boundaries Commission shall ensure that A, whatever voting method is used, the system is simple, accurate, verifiable, secure, accountable, and transparent. B, the votes cast are counted, tabulated, and the results announced promptly by the presiding officer at each polling station. C, the results from the polling stations are openly and accurately collated and promptly announced by the returning officer. And D, appropriate structures and mechanisms to eliminate electoral malpractice are put in place, including safekeeping of elections materials, unquote. This provision places upon the first respondent the onerous responsibility of devising and deploying election systems that the voter can understand. The first respondent must further be expected to provide access to crucial information that can enable either a candidate or a voter to cross-check the results declared by it with a view to determining the integrity and the accuracy thereof. In other words, the numbers must just add up. We note in the above regard that even where Parliament found it necessary to make provisions for a complementary system, it would not escape from the dictates of Article 86 of the Constitution, in line with Article 34 of the Elections Act. The first respondent, through counsel, alluded to some form of complementary mechanism. However, the description of such a mechanism did not appear to us to meet the yardsticks of verifiability inbuilt in the Constitution and Section 44A of the Elections Act. In their submissions, counsel for the respondents and the second interested party urged us not to annul the election on the basis of minor inadvertent errors. We entirely agree. We have already categorically acknowledged the fact that no election is perfect. Even the law recognizes this reality, but we find it difficult to categorize these violations of the law as minor inadvertent errors. Iebc behaved as though the provisions of sections 39, 44 and 44A of the Elections Act did not exist. Iebc behaved as though the provisions of Article 88